Before going into my class, let me introduce my research assistant. His name is Oh-Hyung Lee. Uh, so can you introduce yourself, Oh-Hyung?
Hello guys, nice to meet you. It's the first time to hello to you guys. I'm assistant of Professor Hall, and my major is administrative law. So yeah, nice to meet you again.
Okay. So before going into class, so can I ask every one of you to open your video? So because I want to this class to be mutual, yeah, interactive. Okay, let's go to class web page. So we had another class at April, so that was already long time ago. So April 12th. So in that class, we did a brief overview of privacy protection law and regulation in Korea. So mostly focused on COVID-19 pandemic situations. So I hope with that class, you could have got a small grip of the the framework of Korean how to say law and regulations on privacy and pandemic issues. So after that, so we met again today, so which is May 17th. So today's topic is AI and privacy, and I provided 2 slides and 2 papers, so which is quite a lot. So I hope you already read all the papers and slides, even though not all of them are written in Korean. Um, so so we will meet at the next Monday. So the topic is jurisprudence and AI. So finding law in the age of AI, because the reason why I included this topic is the the AI and ethics is facing its border onto the normative standards, and in that respect, we need to understand the basic understanding of jurisprudence and the basic understanding of finding out what is law and what is justice or something like that. So which is quite academic, but I hope that topic should be also very interesting. And May 31, so we will deal with AI ethics and law in healthcare. So I'm preparing this topic with Bo-Hyung Lee, but I I already checked your midterm papers, so all of them are quite impressive and well prepared. So and I was very much impressed that quite many AI applications or services in healthcare area has been already developed and provided. And with that, some papers, maybe all of you have already um, dealt with some issues, AI ethics in AI ethics or issues in healthcare. So maybe from today, so we can develop the issues and questions on that topic, and maybe we can go more deep into that issues on that day. And maybe the last day with my class would be with me would be on June 7th, and the topic is the administrative decision making through AI and then judicial review. So this is focusing on AI decision making in the field of public administration. I mean, not in the private field. So when the AI technology um, is more developing in the future. So it is far clearer that major administrative decision making, so which could be limiting your right or freedom, or some agents' actions might be some benefit giving to you, or something like that decision could be made by AI. So which is different from kind of human decision making until now. So in when that age comes, so what could be the legal issues and how that agent's decision making by AI or database could be reviewed by judiciary. So which is another quite interesting and important topic. So my lectures in this semester is composed of that topics. And so let me go to, so this is the materials I prepared for you. So this was the slide we used at the first class, the protection of privacy under the COVID-19 pandemics. And so we didn't go deep into these issues, but this is about so-called Data 3 law, the revision of Data 3 law, including data protection law in Korea, which has been enforced from quite recent, maybe last August. So, and this is including quite critical and phenomenal issues and topics. So, which is quite relevant to your research and this class. And from this, maybe you were provided for these lectures. And we have already 2 slides and 2 papers, which are composed of quite many pages. So I cannot, and I would not go lecturing these materials from page to page, from one to the end. Maybe based upon the understanding that all of you have already read and maybe tried to understand the topics, I will give us some brief overview of the topics I'm dealing with these papers and topics. And after that, I'll go to Q&A sessions and ask your ideas and whatever, which could be related to my paper or which could be related to your term papers. So with that questions and comments, you can go this class more, how to say, in a collaborative way. So this topic, which is written in Korea, it's about the protection of privacy in the age of AI. And this is composed of this section 5. So this is dealing with firstly the so-called Lineage 2 case, which is quite popular and famous online game service in Korea. And this was, so the Lineage 2 case was, that was the year of 2006. And as far as I know, as far as I remember, that this was the first case in Korea, so in which the data protection in the internet has been dealt with by the court. So this is kind of this was the first court decision on data protection. So the year of 2006 was even before the enforcement of Private Information Act, which was from 2011. So this was quite, how to say, new and phenomenal case. So in this case, so quite many legal issues has been dealt with, but the major topic was how to define the concept of private information. And after that, in the section 3, I tried to think about the protections and the utilization of the private information. And section 4 is dealing with the the protection of private information in the age of artificial intelligence. this is quite beautiful image, maybe provided by this game. Maybe some of you are familiar with, and some of you not familiar. So I will not go in deep detail, but maybe you can ask me the details of this case. So in this case, so somehow I at this time, so I was serving as a judge in Korea at the Seoul Central District Court, and somehow I was in charge of dealing with this case. Maybe you can find my name at the column of the name of judge. So in that sense, I can say that I was kind of the very person who firstly and seriously thought about these issues in Korea. And yeah, this is the front page of major daily newspaper in Korea. And somehow I don't know why, but I can imagine that the article on that court decision has been provided at the first page, at the main title of this newspaper. Coincidentally, this was the day when the owner of Hyundai car company has been arrested, so which is another quite big news in Korea. Generally, this news should keep the main article position, but somehow, yeah, he was in the second column of this newspaper. So as much as at this time, so these issues and this court decision has been, how to say, well, very much interested by the Korean societies. So after this decision, maybe you can see that there were quite many similar data protections issues and court decisions in Korea. It's up until now. So with this stream, so we can think about the concept or the definition of private information, which is basically composed of the concept of identifiability issues, which is quite similar to European attitude in GDPR or the other regulation before GDPR. So, and as far as I know, even in the United States, the definition of the private information is quite similarly defined, focused on the identifiability of some people, living person. And with this focusing on the identifiability of the living person, so there happened quite many tricky legal issues in to what extent that information is protected as private information, and to what extent over, so that information is not private information anymore because it is not keeping that identifiability perspective. So this is kind of the cases and issues in Korea. And so in this section 3, so I was briefly summarizing the law and regulation of Korea on data protection and utilization. So this is somewhat out of date in the sense that this is the contents before the revision of so-called Data 3 law in the last year. But I can show you that before the revision of that act, what was the legal or factual issues and topics in Korea, and that issues, how that issues has been how to say modified or overcome by the revision of that 3 law and regulations. So it's about how to say the collecting of the information. So as you can see, so in the before the revision, so the Data Protection Act is allowing the collecting of personal information so only under two conditions. The first one is when the prior consent of the owner of that information has been acquired. And the second one is when there's some special law and regulation about that issue. So this is somewhat kind of side of that issue. So in the sense, the main condition for the users of private information to collect, he or she has to get the prior consent from the owner of that information. So this is quite same in the provision or providing that information to the third party. And so when that the company or industry is not keeping that regulation, so they can be under the liability of severe damages or tort damages, and they can be under the criminal penalty or administrative penalty, which is quite strict. So I will skip that part. So I can say that before the revision, so the Korean Data Protection Act is composed of highly strict opt-in way of protection of private information. And it is also taking into the legal tort law damages and triple damages and criminal penalties and dual penalties for both industry and the person who behaved that illegal act. So in the sense that law and regulation has been quite strict, but I should say that the reality was not fully following that the expectation of that normative standard. In that sense, huge gap between the norm and reality has been existing in Korea. Not just in Korea, but also in the other countries also. And this was the basic understanding of the data protection law in Korea. And these issues has been developing so until now. So with the technological development of big data and AI. And so, as I mentioned at the last class, that these issues of data protection or protection of private information is having its origin of the protection of private life or privacy or the right to be alone. So, but nowadays, as we all know already, so in modern society, the data is working as so-called the oil in the information societies, so that the surroundings and conditions of these issues has changed already, quite a lot already. So in this sense, not just the protection of the information, but also the utilization of that information is very important. So, so how to harmonize or balance both various very critical issues in Korea. In this sense, before the revision of Data 3 law, for the industry or some institution to utilize that information, they have to do kind of this work of anonymization process. So, and with that issues, so the concept and the way of anonymization has been quite hot topics include in Korea and worldwide. Maybe I could see in one of your term papers, I could find this HIPAA issues. Maybe you can add some information on this topic later. yeah, this is the worldwide topic surroundings. And the section 4 is about protection of data or private information in the AI. Maybe you know better than me these pictures. I can say that in the age of big data, AI or smart grid or microgrid, the essential or the critical topic is data. And for the collections and utilization of that data, in every aspect, the issues of private information issues are existing. So, and how to deal with these issues in the factual side, but also in the normative side is very critical. And yeah, you are quite familiar on these terms, like the accountability and transparency or explainability. So these are how to say the key concept and key guidelines to how to understand how we should build up the legal framework for data protections in the age of AI. And I can see that all of your term papers are analyzing the healthcare service and this ethical perspectives. So these are the main topics and framework of the first slide. And let's see. So this is kind of more deep into analysis of how to say the requirement to deal with data or private information in the legal perspective. So at the previous slide, so they are required to acquire the prior consent to collect and provide and utilize that information. And in this slide, so I go more deep into the topics that require for data collecting and providing and utilizing. So this is basically about the topics and how to modernize or how to rationalize on that requirement in the future from the standpoint of kind of 2 years ago before the revision of the data law has been enforced or before the European GDPR has been enforced. So this slide is dealing with the topics. And maybe some of you who are quite young, maybe undergraduate students, are not familiar with this kind of Chinese character. I don't know how you're familiar with these old characters, but this is my paper, which was written very long time ago. So right after that court decision, I delivered in 2006. And maybe this was the moment I moved to the university right after that court decision. So as a professor or as an academician, so I was trying to delve into how to say theoretical or practical issues surrounding that court decisions. So it's quite long paper. And this is another paper dealing with the big data legal issues in Korea. And this paper is basically dealing with the legal issues, how to harmonize or balance the protection and utilization of the private information in the age of big data. It's quite, how to say, framework or overview analysis of these topics, because I don't know. So this was 2014, so it's already 7 years ago. So I can say that in Korea, at the time. So the concept of big data was quite, how to say, newly beginning to be focused on in Korea, and in that sense, I prepared this papers. So with this, I briefly gave the explanation of the 2 slides and 2 papers and the factual and legal topics included in that materials. So now let me open the floor, and you can freely give me your questions or comment about these topics. Nope. So everybody no. Okay. So who is that? Choi Yun-bin?
Yep.
Yeah.
I searched several global standards of electronic health records, and I do not know that detail of those all standards, but is there any standard of for in Korea, or is there any special characteristic of, for those electronic health records in Korea?
Yes, good. That's quite good questions. And can I ask Yun-bin? So what is your topic of midterm paper?
The company is called ISD.
ISD, right? Yeah, it's about kind of medical kind of I don't remember about what to say, operating mechanism or something like that.
Yeah, it used topological data analysis for hospital administrators.
Yeah, so that was quite interesting topic. So let me first answer your question. So of course, there is special law in Korea dealing with that topic. Maybe your question was about the electrical, how to say, information of patient or medical process like that.
Which is
Yeah.
collected by hospitals.
Yeah, right. So we have that the basic framework act of 의료법. How I don't know how it is translated. It's about act on medical or something like that.
Medical law, right?
Medical law, yeah. Actually, this Bo Hyung Lee is the expert on that topic. Maybe he can have his role and later. And in addition to that, so we have also specialized Data Protection Act in medical field also. So it's dealing with the sensitive information of the patient related to medical treatment or something like that, or how the patient can deal with their information or something like that. But one tricky issue is about the relationship between that specific law on medical field and the basic framework of data protection law in Korea. So the latter is the general act, which is governing actually in every field of that in our lives, unless it is explicitly exempted by the special regulation. But that relationship has been having some blurry part in the past, and including the contents of the law and the governing mechanism of that law. So in the revision of data law, so we tried to modify or repair some part of that. So I can answer as that much. So was that, yeah, of course not enough, but was that, yeah, answer for your questions? So thank you for your good questions. And as there was the first questioner, maybe you feel free to write another questions.
Actually, I have a question too, but like my question is not related to the assignment, but related to the paper that professor gave us. Like compared to the time when this judgment was written, I think there have been many changes in the Personal Information Protection Act. So like currently the legislation itself has been revised a lot, and also the consumers and the companies have a lot interest in the consumer privacy. So like the interest has also increased. So like I wonder if the professor will make the same ruling when on the same case from the present point of this time, like about the lineage cases, like on nowadays, yeah, with nowadays law, like it's just personal, question.
Okay, so you're asking by personal, how to say, idea or attitude. So if I were dealing with that case, kind of right now, what would be my final decision or something like that? Is it right?
Yeah.
So yes, you are very correct that. So in the meantime, between the year of 2006, when that court lineage 2 decision has been delivered, and year of 2021. So actually, I didn't imagine that the year of 2021 will come through me when I was writing that decision in the 2006. So yeah, 2021 is kind of much too future in that time, but somehow I'm living at that time, so I cannot believe that. But yeah, as I mentioned, in the year of 2006, so we didn't even have the Data Protection Act law. So that was first enforced from 2011. So so I can say in the year of 2006, how to say at that time, so many internet service, including game service or the first stage SNS service, like maybe some of you didn't hear about that kind of the Cyworld or feature or something like that has been popular in Korea. So, but some kind of basic form of how to say social marketing or internet marketing has been so opening that market in that time. So at that time, so every players, the most important part was how to collect as much users and how to say people to join their service, and in that entering that stage of the service, they were requiring quite huge amount of personal information. So actually, they didn't know what was the legal meaning of that requirement, but without that acceptance, the people could not join that service. So, with that kind of just huge amount of personal information or data has been beginning to be accumulated in that business or industry. But actually, I mean, nobody in that industry did not realize how much important the protection of that data is important, or how much they should be cautious in dealing with that information. So in that time, that data collected in that way has been too easily and too recklessly, how to say, leaked to outside and was utilized by some not good purpose, including criminal intent or something like that. So that was the situation in Korea in 2006. So, but there was no social consensus or legislation to deal with that topic. But in that stage, and there was no prior court decision before that time. And in this situation, that issue and the case came to me as a judge. So I had to deal with or solve that issues in Korea, so actually from scratch, or maybe researching or inventing the concept by my own, how to say, idea and effort. So that was the situation at the time. But as Sang Yu-jung has mentioned, after 2011 until now, so and after experiencing quite many, how to say, accident and event of private information issues, so the Korean society got much more interested in that topics, in the issues of protection of data and private information. But somehow I can say that with that hugely abruptly changed way, that that how to say, that trend got too much inertia to protecting that information, only protecting that information. So once that protection has been damaged, then huge penalty or liability should be given to the industry. And so the recent 4 or 5 years has been the time or the effort to change that, how to say, trend, because the surroundings globally has been changing in the age of big data and AI. And I can mention another point is that that the huge development and change in Korean law and regulation has been mostly done in the field of administrative regulation or administrative decision-making process. So, so which agency will have authority on that topics, or what kind of penalties or what kind of agency actions can do about that topics. This is the main field of that topics. And I can say, I should say that the legal issues I was dealing with in the year of 2006 was not administrative court decision. So that was civil law damages cases. And in that sense, that legal issues are still quite valid in the year of 2021. Even though, as I showed briefly, so in the Data Protection Act, there are some special articles like triple damages or to say the legal damages amount or something like that. So which is quite how to say, helping to solve that civil law damage issues. But still, the main legal issues are the same in Korea. So in that sense, even at this time, even though I'm not a judge anymore, so if I were dealing with that case, the basic, how to say, the considering pathway would be much similar, even though I have quite helpful, how to say, tools around, but the basic way of thinking would be the same. And so, was that an answer for your question?
Yes, thank you.
Okay, so with this conversation, so can I ask, what is your topic of your paper?
Our team was like about Sensely
Sensory.
It-
What service is that?
service that like before going to the hospital, by using the app and by using the chatbot, like the avatar chatbot, it's like diagnosed before going to the dentist or like
Yes,
yeah.
I remember that was quite interesting service. And as usual, before going to the hospital or go to see the doctor, so I can maybe talk with chatbot or avatar.
Yeah.
But and my status of health and get some maybe help or keep record of my status, right there.
Yeah, yeah.
Yeah, and I could see that at the end of every your term paper, so you are dealing with that, how to say, ethical dilemma situation. So like efficiency versus accuracy, or efficiency versus privacy, or privacy versus how to say, discrimination, or something like that. So Yu Jung-chan, so can you briefly explain to me what is ethical dilemma situation of privacy, related to privacy in your analysis?
Uh, we, like, me and my teammates, like, was think about, like, we are worried about the privacy and the accuracy, I think, like, because the company will be collect the personal data. Like, actually that data is also what like, it's a important and like, it's about, like, the data is our medical data, so it will be more, like, sophisticated, and also it's really important and a little bit more privacy concern. But, like, if the chatbot keep collect our data, then we are worried about if the company might use our data or sell to other company, or the kind of thing can be happen. So, like, we are worried about, like, personal data can be selling or retention or used by others. And also, like, we don't know the algorithms, like, whether that algorithm is really accurate or not. We just have to believe in what chatbots are saying, or what the engineers gave us. So, like, general consumer cannot judge the accuracy of the algorithm, so we have to just believe in. So the kind of dilemma can be happen. So, like, I think our group talk about mainly about those dilemmas, I think.
Good dilemma. So, and what is your suggestion or solution to that dilemma?
Well, I actually, like, we don't write about the how to solve this problem, but, like, I think they're like, the company, I think they need some judgment. They need, like, judgment phrases, things should gave to, like, well, it's really difficult question, so, like, I don't know how to say right now. But, like, yeah, I think we have to talk about with my teammates more about that issue. Sorry.
So sorry about that difficult question.
No.
But I can say that difficult question is maybe one of the critical, or the most important part of this class in this semester, I guess. And according to in what way, so we can find out way to solve that dilemma situation. The outcome will be hugely different each other, and the payoffs for each players in the service will be quite different. So this is still another quite difficult question, but I can say this is affecting very seriously, not just in the legal aspect, but also in the technological development issues too. So, for example, so in the, how to say, automated driving system, so I understand that in the technological perspective, so that has been already highly developed. You know, maybe last year, so there was some news that some big accident happened in maybe Silicon Valley. So with that test driving, automated driving system, the fact that that accident has been reported in that importance and in the seriousness, so that means that in technological side, it has been much developed than just people expectations. So because that accident rate is already lower than human driving. So, but the critical issues which will decide the future of automated driving is so-called the liability issues when the accident happens. So in the age of until now, when the human beings are driving, so the liability issues are solved by leaving the damages accountability to the person who are in charge, who are negligent in that moment. But when that automated driving is prevalent in our societies, so how to solve that liability issues is very critical. So whether that liability can go to the algorithm developer, or whether that liability can go to insurance company, or still the liability can go to the people inside that car. So according to that legal decision making, the future of the technology can be hugely different. And I can easily guess that this situation is much similar to healthcare technology or healthcare AI service too. So in this sense, so it will be very, how to say, not easy, but interesting topic for you to think about that the solutions to of that dilemma situation related to privacy or protection of information versus some other values like accuracy or discrimination or fairness or something like that. So, okay, so thank you very much, Yu-Jung Chang. So I just thought, so I was begin this lecture just 30 minutes ago, but I'm somewhat surprised that we spent quite already, 9 minutes already. So, okay, so that was the topics and materials I prepared for you. And I know that all the issues has not been fully covered and understood by you. So I will keep going on talking about that issues until next Monday. And as I did experimentally with Choi Yoon-bin and Jang Yu-jung, trying to applying that legal issues and topics to the midterm report you are preparing. So like that, so I understand that another 6 quite interesting AI service in healthcare are analyzed by you. So other groups can also think about that privacy related dilemma situation in your paper or research, and let's talk and discuss with me, and I will try my best to give not exactly the right answer, but how the legal way of thinking on that topics and the guidelines for thinking about that topics. Okay. Okay. So Lee Bo-hyung, so can you add some comment?
Okay. Firstly, thank you for saying about this issue, and I'd like to say about Yumi's question. So, as you mentioned before about EHR, we don't have enough standard for making some rule about healthcare information, but I heard that some enforce lower law, like medical law, we have a kind of standard, and the government makes some standard for protection of healthcare service and healthcare information. But as you know, the hospital do not have incentive for sharing their hospital information and other patients information. So even we have many standard, and even we have some preparation about sharing their information, but we don't have the incentive for hospital. So even we have a rule, even the government makes some rule for sharing or protection of healthcare service, but as I mentioned, we don't have incentive for EHR. So I think the many startup and many company make some good program and good AI for healthcare service, but they don't get enough information of healthcare from hospital, because hospital even cannot get enough information from other hospital. So so firstly, we don't have standard like Professor Ho said, and even secondly, the government makes some rule for healthcare service. But thirdly, even we have a standard, the hospital does not have incentive for sharing. So I think we have many steps for making AI healthcare service. Yeah, that is my answer.
Thank you very much, Boyoung Lee. Okay, so we will have another chance to hear more about him. So Boyoung Lee, what is your undergraduate major?
My undergraduate major is biology. So yeah.
Okay, he majored biology, something like that. So I understand that that means that he knows something about science. And so after that, he came to SNU Law School, JD course, and finished that course and passed bar examination with very high record. And he became the lawyer in Korea. So now he's serving as his military duty at the Ministry of Justice. Maybe this is, I understand, this is third year, so he's almost finishing his duty, and he is going to big law firm. So which law firm is it?
세종, 신앤킴. Yeah.
Law firm. So that means he is soon to become a lawyer who knows both law and science, and he is also now preparing his doctoral degree dissertation, so with the topic of the regulation issues in the biohealthcare issues. So in that sense, I can say that he can give a great contribution to this class and give help to you. So I expect that role from him. Okay. Okay, so with this, so let's wrap up this class and see you on next Monday. So is there any quick questions or comment? Okay.
Hi. Yeah, hi. Thank you for your lecture. It was really helpful. And it was really a nice chance for me to read your papers because it was, full of very important issues. And then while I was reading this paper, it was all in Korean, and then it's an expert knowledge. So I thought that, as far as I know, there are some students whose native language is not Korean. So I was just wondering if there would be any chance for us to get English version of these papers. I was just wondering if there will be any way.
Okay, so good question and good, how to say, yeah, requires. So There's not exactly the English transcription of that paper, but maybe, as you know, so maybe in the jurisprudence class or material, something like that. So there's another, my English paper, so which was published in United States Mississippi Law Journal. So that paper is dealing with the same case and legal issues in this paper. So maybe who are not native in Korea, so that paper could help a lot for understanding the cases and legal topics. And in addition to that, the legal philosophy or jurisprudence issues, which is quite essential for your AI ethics understanding. So I hope. Okay. So with this, so let's say goodbye and see you next Monday. Thank you, everyone. Bye.